To the third meeting in 2020 of the Committee on the Scottish Government's Handling of Harassment Complaints. Before we begin our first evidence session, I think it's important to reiterate what the remit is for the committee's inquiry, how the committee intends to conduct the inquiry, and a reminder of the purpose of this first evidence session. The committee's remit is to consider and report on the actions of the First Minister, Scottish Government officials and special advisers in dealing with complaints about Alex Salmond, former First Minister, considered under the Scottish Government's handling of harassment complaints involving current or former ministers, and procedure and actions in relation to the Scottish Ministerial Code. This committee's approach will be to establish where issues arose in the handling of the complaints and the actions in relation to the Scottish Ministerial Code. Consider what actions were taken that gave rise to these issues. Consider whether the policies are sufficient and fit for purpose, or whether it was the application of the processes that gave rise to these issues. Consider whether robust governance of policy evaluation and decision-making is in place. And consider whether any lessons could be learned to avoid the issue arising again. The committee will not revisit the separate matter of the criminal proceedings brought against Mr. Salmond, nor reinvestigate or consider the substance of the complaints originally made to the Scottish Government. The Scottish Government written statement sets out the background to the development of the harassment policy, including consideration of organisational culture in the context of the results of the 2016 People Survey. Issues about organisational culture are likely to be an ongoing theme. It's important to stress that we are looking at this in relation to how that culture played into the development of the harassment policy. This is about the collective culture and values of an organisation, namely the Scottish Government. It's not about looking into individual situations, behaviour or specific cases of concern. We have agreed that we'll break down the inquiry into three general headings. 1. The actions taken in relation to the policy on handling harassment complaints. 2. The judicial review. And 3. The actions taken in relation to the Ministerial Code. Today's session will focus on the first of these, the development of the policy on handling harassment complaints. Our agreed approach to our inquiry and also our statement on how we will handle information and evidence have already been published on the committee's website. The parameters set out in the written statement apply to the conduct of everyone, including committee members and witnesses. Finally, as we set out in our written statement on the handling of information and evidence on our website, it is vitally important that everyone who takes part in our proceedings complies with both the court order made by the Lord Justice Clerk, Lady Dorian, that prevents publication of the identity of or information leading to the identification of the complainants in the criminal proceedings, and the court order made by Lord Woolman that prevents publication of the names and designations, past and present, of Miss A and Miss B, who raised complaints under the harassment policy, or publication of information which would lead to their identification. This means that not only should the names and designations of the complainants and Miss A and Miss B not be disclosed, everyone must avoid disclosing information that could lead to jigsaw identification in light of material in the public domain. Given our responsibilities, please be aware that I may have to suspend the committee meeting if we come up against any issues in relation to our obligations under the court orders or other legal issues. With that said, we will move now to agenda item 1. And prior to that discussion, I understand there are committee members who wish to make declarations on record.
Thank you very much, Convener. As this is our first evidence session, I want to reiterate what I placed on record at our very first meeting, and that is that as a former minister, I attended Scottish Government Cabinet between 2011 and 2018. Thank you.
Alistair Allen.
Thank you, Convener. Likewise, although not in the Cabinet and not involved in any way with the development or implementation of this policy, I was, as people know, a Minister between 2011 and 2018.
Thank you, both of you. Agenda item 1 is a decision on taking an item in private. Oh, terribly sorry. Maureen Watt.
Thank you, Convener. As you know, I too have been a Minister in all three SNP governments from 2007 to 2009, 2011 to 14 and 14 to 18 in different roles, but again not in the Cabinet, although I have on occasion substituted at Cabinet meetings.
Thank you, Ms Watt. We will now move to agenda item 1, which is a decision on taking an item in private. And I would ask members if they agree to take agenda item 3 in private, as well as all future discussions of evidence received in private at subsequent meetings and discussion of the work programme in private at our next meeting on 25th of August.
Agreed.
Thank you very much. We now move to agenda item 2, which is Phase 1, Development of the Scottish Government Policy on the Handling of Harassment Complaints involving current and former ministers. And I would like to welcome today's witness, Leslie Evans, Permanent Secretary of the Scottish Government. As previously agreed by the committee, I will now ask Ms Evans to make a solemn affirmation. Ms Evans, please repeat after me. I solemnly, sincerely and truly declare and affirm that I will tell the truth, the whole truth and nothing but the truth.
I solemnly,
Sincerely,
and
truly
declare that I
and affirm
that
I will tell the whole. Now you're getting me confused. That I will tell the whole truth. Sorry, I'll start again. That I will tell the truth, the whole truth, and nothing but the truth.
I will tell the truth, the whole truth, and nothing but the truth.
Thank you very much. And I would now invite Leslie Evans to make an opening statement for up to 10 minutes, please, Permanent Secretary.
Thank you, Convener, and thank you also for accommodating my attendance at Cabinet this morning, which is much appreciated given issues preoccupying the Government at the moment. As is standard procedure, but for the record, I want to be clear that I and any civil servant giving evidence to committee will be doing so on behalf of ministers and not in a personal capacity. Also, I shall limit my opening remarks to the issue on which I know you are taking evidence this morning, the development of the procedure to handle harassment complaints involving current or former ministers, and the period to be addressed October to December 2017. Convener, underreporting of sexual harassment appears to be endemic across most organisations and institutions. In response to the Scottish Parliament's own survey question on what action staff had taken in relation to sexual harassment incidents they had experienced, the most common response was they had not done anything at all. Every single one of us has a right to a safe workplace free from harassment. The Scottish Government recognises this as a legal responsibility and a duty of care to all employees to create a culture where such behaviours are simply not tolerated. The Scottish Government has been on a journey of cultural change since 2015 to ensure the organisation is more open, capable and responsive. As Permanent Secretary, I have led a focus on equality, inclusion and well-being, including addressing bullying and harassment. Now, this is still work in progress, but there is evidence of improvement. Our most recent People survey showed a marked increase in the reporting of bullying and/or harassment, with 57% of those who had experienced bullying and harassment saying they had reported it. This is up 19 percentage points from the previous year. Staff's positive experience of inclusion and fair treatment reached its highest ever score at 83%. This is amongst the highest in the whole of the UK civil service. So the hashtag #MeToo movement, which grew in 2017, drawing attention to the historical nature of harassment which had not been reported and dealt with, it added a welcome but additional momentum to an existing programme of work. For the Scottish Government, the logical next step was to review its own procedures. I was commissioned to do so by Scottish ministers on the 31st of October 2017, and by the then Cabinet Secretary and Head of the UK Civil Service, Sir Jeremy Hayward, on the 3rd of November 2017. The Scottish Government's response to that review, in line with wider work, was to challenge a say-nothing culture, to give staff, all staff from any part of the organisation, confidence that concerns and complaints could be brought forward and would be addressed. Having considered the relevant policies, it was concluded that to address an identified gap and to clarify existing provision, a procedure to investigate complaints of harassment should be developed for former and current ministers. This built upon the expectations set out in the Ministerial Code and our existing Fairness at Work policy. The Scottish Government remains ahead of many other institutions in designing and implementing such a procedure, openly and transparently, and particularly one to address historical allegations of sexual misconduct. We did not shirk our responsibility. As civil servants, every process we create must be robust and fair, open to appropriate challenge and scrutiny, and reflect our civil service code and its core values of integrity, honesty, objectivity, and impartiality. Creating this new HR procedure was no different. There was an extensive and iterative professional drafting process led by the team in the Scottish Government, which is responsible for offering advice on the operation of the Scottish Ministerial Code and all matters of propriety and ethics. It was informed by legal advice throughout and followed HR best practice, drawing on ACAS guidance, and it sought appropriate external engagement, including with our trade unions. When complaints were raised, it would have been unconscionable and a failure in our duty of care not to investigate those complaints. However, it was accepted at judicial review that one part of our procedure should have been applied differently. I apologise unreservedly to all concerned for this procedural failure. We've already learned early lessons from this experience as part of work being led by our People Directorate, and we also await the findings of the review which I commissioned, externally led by Laura Dunlop QC, and which is now underway. But it remains the case that the investigation of those complaints was the right thing to do. Convener, I'd also like to take this opportunity to underline for the record the Scottish Government's commitment to cooperating fully with this committee. That commitment is underpinned by action and evidenced by multiple dossiers of information that have been preserved and provided to the committee within agreed timescales. This work has been complex and time-consuming in order to ensure compliance with legal, data protection and confidentiality restrictions. I'm happy to elaborate further on these points to demonstrate both the seriousness with which the Scottish Government has approached its engagement with the committee and additional measures which were put in place to ensure all relevant information would be provided both before and indeed in parallel with responding to the COVID-19 crisis. In closing, Convener, I'd like to make 3 important points. Firstly, the Scottish Government is and remains ahead of many other institutions in designing and implementing a procedure to address harassment, and particularly to address historical allegations of sexual misconduct. I am clear that the Scottish Government acted in good faith. The transparency of our written procedure means that it is open to challenge and scrutiny. I accept that scrutiny. We shall apply the learning. Secondly, the procedure was and is to safeguard all staff and to assure them of the standards of behaviour they are entitled to expect in their workplace. It was developed with the professional rigour and values you would expect from the civil service, informed by legal advice and HR best practice. But it was designed as an HR procedure, not a legal instrument. Thirdly, and finally, in her 2018 report into bullying and harassment in the House of Commons, Dame Laura Cox found People who have been bullied or sexually harassed or have seen this happen to others are generally reluctant to come forward and report it. By creating the culture and environment in which complaints of this nature could be raised and in which subsequent investigations of those complaints could take place, the Scottish Government did not take the easy path, but it is the right one. Thank you.
Secretary, I know that all the committee members have a lot of questions to ask, and culture and environment, as you referred to towards the end of your statement there, is one that Margaret Mitchell, followed by Alison Johnson, would like to raise. Margaret Mitchell.
Good morning, Permanent Secretary. You mentioned fairness to work, and I think if we look at the development of policy, it would be really quite helpful if we were to put this in context. And I wonder if you could just give a brief outline of how the policy developed from dignity of work, or just exactly, you know, when fairness at work came in, right up to we get to the point in 2017 where we've got the internal procedure.
Expert. Sorry, I'm not an expert on the fairness at work policy, but it was introduced originally in 2010. It was and is still intended to predominantly cover everything except harassment. And you'll appreciate that we wanted to ensure, when we looked at fairness at work, which was negotiated and agreed with our trade unions at the time, has been used and applied and tested, and is a process for handling including a number of stages. So it has an informal as well as a more formal element of it. And finally, it does interact with and bump up against, as you would imagine, the Ministerial Code. When we were looking at what the gaps were in the review that we were commissioned to undertake, it included looking at how fairness at work operated, what it covered and what it didn't cover. So, for example, it had some very basic elements of it, such as no time bar, which we agreed we would want to include in the new procedure. But it also had some lack of clarity about where it docked into the Ministerial Code, and where it had been used, there'd been experience of how well it had operated and how clear it was in terms of the responsibility for what took place in fairness at work, and where that translated and transferred into Ministerial Code. So you will be, I'm sure, calling witnesses who are more expert in HR than I was, and who perhaps may have been involved in creating that policy, but it had been existing and used since 2010.
Yeah. I wonder if I could refer you to the FD, who referred to as an extant policy, and one which was looked at something of a flagship policy, in that the FDA said that it allowed looking at the conduct of ministers, not through the opaque Ministerial Code, but through this policy. However, they do go on to say that despite the Scottish Government introducing this policy with the clear process for civil servants to raise certain complaints about ministers rather than relying on the opaque Ministerial Code, this has not proved effective in eliminating behaviour that causes concern. So there's two things I'd like you just to clarify. When we're talking about complaints, are we talking about expressions of concern about certain behaviour, as well as formal complaints? And if you would agree, because I understand you took up your post in 2015, if that was a fair assessment of the fairness at work policy.
Permanent Secretary.
So to take your questions in two parts, there is a differential and a marked differential in all the policies, including fairness at work, between raising a concern and lodging a complaint. I think this sometimes is regarded as some kind of a bureaucratic differentiation. It really isn't. And if you look at the fairness at work particularly, there is a whole part of that policy which is, again, traditionally and now even more so focused on bullying rather than harassment. So we would turn to the fairness at work policy for bullying rather than the new policy that we now have for harassment. When you look at that, it has a whole stage outlined which is about informal resolution. and the kinds of techniques, processes and support that can enable that. I would just emphasise on that basis that we would, I think like any organisation, and certainly I know in HR good practice, it would be expected that if a concern is appropriate to be resolved at informal stage, it really should. And there are many ways of being able to address that in terms of mediation, conversations and so on. So there is a very different distinction between concerns and then people deciding whether they then want to actually trigger the formal process by making a complaint. And we may come back to that in terms of the other procedure. Your other comment, I think, was whether or not it was fit for purpose. And I think this was one of the reasons why in the commission from Cabinet we took the opportunity to check and see what our experience had been and what the gap analysis was. And that was undertaken by our HR specialists, looking at fairness at work, how it had been applied, where it had been applied, how successful it had been, and what gaps it still showed in its application. That was the groundswell of work that produced the first iteration of the new 2017 procedure. That gap analysis of where fairness at work had worked, where it didn't, where it was confusing, and where, and I think you used the term opaque, I think where it was not clear how the Ministerial Code docked into that fairness at work procedure. So that was the very early stages of drafting the new procedure, was to look at fairness at work and see where the gaps were.
Yeah. So can I be clear, just when you took over in 2015, looking at this policy, obviously you would be briefed. Can I understand how you were briefed? Was it in face-to-face? Was it through email, text, etc., about how the fairness to work policy had been working? You formed a view on that, and can we just confirm that within that view, you included expressions of concern as well as formal complaints? And from then, what did you, in your capacity as the permanent secretary, the most senior civil servants, principal advisor to the FM, strictly to the cabinet, what did you do in the period leading up to the point where we have the People's Survey, which was fully a year and more later in October 2016.
And then we'll move on to Alison Johnson, Permanent Secretary.
So when I took over, I would be briefed by the person who was in charge of HR at that time, not particularly on that policy, unless it was required to be enacted in some way. I was taking over an organisation where there were probably thousands of policies, so I was not briefed specifically on that and wouldn't expect to be. But I would expect to be able to go to my specialist staff and the head of HR as and when required to learn more about how these processes were working, how effectively they were operating. At the time, I think it was I would need to check this date, but the first time that I became aware of the fairness of work policy in action was to do with a particular point and concern which was addressed as part of the informal process. I would, again, just to say I would need to confirm what that date was, but I was aware when that case was being raised, and of course I would not be involved in that, that would be the head of HR who were applying that it was not always clear about how the policy interacted with the Ministerial Code being addressed. And of course the First Minister is the ultimate arbiter of the Ministerial Code. So there were issues raised around that time that I was aware of, which prompted work to start at looking at where the fairness at work process could be improved, how that policy might be enhanced or revised. So that was already on the radar at that point. The review that I talked about subsequently coming out of the Commission from Cabinet exacerbated and intensified work that was already on the agenda.
I'd pin you down, just not to the exact
Please
date,
be
but was
quick,
it between
Margaret.
2015 and between the People's Survey in that year plus?
Yes,
sometime
The
then?
People's Survey in 2016 would have come around in the autumn of that time. That would have been the first full year that I would have been in role at that point. So we would have had a People's Survey in 2015. We have it every year. So there would have been the first one in around September 2015. And
Did it happen before that? Any issue to do with how there was a problem with the fairness of work? Were you aware of anything? And how were you briefed, if you could?
I was aware of the application of the Fairness at Work policy, that it was being used at some point, and the issues that were being, I can't quite remember the date, and I'm being absolutely upfront with you here. I think it was early 2016, but it may have been early 2017. And I will write back to you with that date for exact purposes.
Aware of anything else that caused you concern about the fairness at work policy up until that point?
I wasn't aware of it, no.
And you weren't briefed in text or emails?
Margaret, I think we have to move on to let others question.
I will come back to you on the date.
Thank you. Can I have Alison Johnson, please, followed by Alistair Allen?
Thank you, Convener, and good morning, Permanent Secretary. We're excuse me. We're advised in our papers that that you met deputy directors across the Scottish Government to discuss organisational culture in response to the People Survey of 2016. Excuse me. The survey contained a question on discrimination, harassment and bullying, and it seems that the survey has clearly played an important role in policy development since that time. And of the 11% of people who said they had experienced discrimination, harassment or bullying, only 34% said they'd reported it, and only 20% of people regarded the issue as having been resolved. Yet we're also advised that few formal complaints were received over the same period, and the Scottish Government has stated that this suggested a possible lack of awareness of or confidence in existing processes and procedures. And I would just like to understand better, Permanent Secretary, is it your view that at that time reporting channels for those who wish to report harassment were clearly defined?
Yes, in that there was a Fairness at Work policy, and so people were aware of that. I think it takes more than people, if I may, I think it takes more than people being aware of a policy for them to feel confident about forthcoming in terms of the policy. So, yes, people were aware of that policy, that it existed. I'm not sure how many people would have thought of the first stop. They probably would speak to their manager in their first line rather than automatically go to HR for the policy to be activated.
I mean, I think it's notable that only 20% of people regarded the issue as having been resolved, and perhaps that plays a part in people's reluctance to come forward. I'd just like to understand if it was clear that there would be no victimisation or retaliation against people who did complain.
Absolutely. I mean, I think if we're talking about after the 2016 results, I took some very particular action as a response to those results. I appointed a senior director to lead a particular piece of investigation and research work on culture and how culture affects bullying and harassment. And that was not a book studying piece of research, that was live research working with our HR people and specialists about how we could ensure that our culture was one that would welcome and appropriately support people who came forward with concerns. We also did a very distinctive and very particular piece of research in looking at both the protected characteristics analysis of people who are coming forward accused of being bullied or harassed. So were there some people, for example, from minority ethnic community, was it higher there? Was it more people with disabilities and so on? So there was a piece of particular research there. And we also looked very carefully at what we call the hotspots. So where were there places in the organisation that seemed to have higher levels of bullying and harassment in their directorates than others? And why was that? So we commissioned work on that diversity and on those hotspots. And the senior director used that, as well as I said, expertise, to look at what the cultural changes would need to be. And final point for me on this, I had spent most of 2016 as a theme trying to support and encourage and invest in our managers. And when I say our managers, I'm not talking about the very senior managers, though they were part of it, but it was also about frontline managers, so that managers were more aware of what preventative work could be done within their teams and others to ensure that the culture was as it should be, thriving, inclusive, diverse, and so on. So there was a significant amount of work that took place after the 2016 results, which I instigated. But there was already work underway about how the environment and the management setting of the organisation could be inclusive, diverse and supportive.
Can I ask one further question, Convener? Thank you. You refer to hotspots there, we're advised of an attachment to an email. I think it's part of a staff communication from yourself, which suggests that perhaps particular pastoral care in communications and private office at this time may be helpful. Could you elaborate on why that suggestion was made?
Yes, I think, first of all, just on the hotspots, they're usually, traditionally, and nobody will be very surprised by this, are where you have a large number of staff, often in very distributed sectors, so across the organisation, but in working in very large numbers together, where the line management is quite dispersed or quite stretched, or where areas have been under considerable stress. So we expected to see hotspots where people were perhaps either through the nature of the policy and the exposure that they had been encountering during that time. You would expect to see some slight rising there. But what we were looking at was trends as much as it was particular just blips in the account. In terms of ministerial private offices, we have taken quite a few steps most recently, actually, and I'm pleased to say, incidentally, and at some point I'll have, I hope, a chance to say this, that the 2019 people results are the best results we have ever had in our people survey, including the reporting of bullying and harassment. But I'm sure there'll be a chance for me to share that with you later on. But going back to 2016, we were aware of the fact of the importance of having somebody who could look after the ministerial private offices as a director, as a leader. And we were therefore keen to ensure that that was part of our structure for the future, where you could have, I would expect pastoral care to be part of any manager's role and responsibility. But we know that that working in ministerial offices is incredibly hard work. It can be very stressful. It's very fast-paced. So we were particularly keen to ensure that people didn't feel isolated or without care in that respect.
Thank you. Thank you, Convener.
Alistair Allen, followed by Alex Cole-Hamilton. Alistair.
Thank you very much, Convener. I suppose at this stage of our conversation, we're keen to find out the problem that the government was seeking to fix with its new policies, and particularly, as has been alluded to already, the response that there was to the 2016 People Survey. Looking at the introduction by way of response that you gave, or that the government gave to the committee, along with some of its papers submitted, it's summarised by saying initial assessments, and I take it that was assessments of the 2016 People Survey, identified a number of areas for action, which included work to review the existing fairness at work and disciplinary procedures through the lens of sexual harassment, a review of procedures for handling complaints against ministers or former ministers. Can I ask you just briefly to take us through the steps that were taken immediately on receipt of the 2016 People Survey and the priorities that the government saw in responding to it?
Yes, there is a pattern of response to the People Survey. As I say, it takes place every year. Every department and every administration in the civil service undertakes it. Agencies undertake it as well. It's been taking place for many years, so there is a huge amount of trend data that is accumulated. And as with most years, we have a very in-depth analysis of the data as it comes forward. So we have high-level data, and the data is all actually traced back to the UK government analysis, because they undertake and have the ownership, if you like, the licence for the People Survey. So there is a pattern of response to the People Survey, which means we get high-level data, which we immediately share, and then after that, usually a few weeks later, we get it drilled down into divisions, so way down into the heart of the organisation. And there are several strands of work, but the two main ones that take place on that is we share the results, we analyse the results, and then we question and commission locally, as well as at DG level, what the response to those results will be. And we have got, I think, in our time, better at being able to hone in on those areas that we're of most concern. So the People Board, which is a part of the Scottish Government's governance and assurance structure, which looks after all issues to do with people, HR and so on, would be the first port of call. And I think after the 2016 results, it was the 30th November 2016, so very quickly after results, the People Board discussed the headlines, the narrative, as it were, so what were the things that it was telling us, the story that it was telling us about the organisation, and some detailed analysis on the variation within and between groups that had taken part, so where one directorate was showing very differently to another, but equally where one characteristic, groups of protected characteristics, for example, or maybe women versus men, so a fairly high-level analysis. And then the Executive Board, which is myself and my most senior team, had a presentation on the insights of the survey emerging from that analysis and the discussion from the People Board. We then had a directorate-level analysis, which was shared with every member of the senior civil service. That took place in December. And the trend data, so every director and division knew how they were looking in comparison with others, as well as at their own hand. And also grades, so we cut it by grade too. So if you were what we would call in the civil service a B-band member of staff, experiencing and giving a response in this part of the organisation, how does that differ from other parts and other directorates, and why? So there are two strands to this. The strategic analysis and probing that takes place at the highest level of the Scottish Government and in the depths of the People Board. And there is the very local conversations, probing and analysis that take place for each deputy director with his or her teams, and to question why the results are as they are. And final point, it is statistical analysis, and it is compared at a UK level as well. So we see the outliers, but also there are many free text boxes within the People Survey, so people can say what they want, as well as answer particular predestined questions.
Thank you. And can I ask, related to that, you mentioned the initial analysis of the results of that survey. Was it at that point, or was it not until later in 2017 that the question of whether the issue of ministers and former ministers specifically, that the rules around those specific issues were in need of review? Was that something considered initially, or only in 2017?
Sorry, I interrupted you. The bullying harassment came forward, as it always does, and is always a point of interest and probing and analysis in every survey, and the 2016 was no different. The point about ministers past and present was particular to the circumstances of the 2017 procedure, in that the gap analysis, as I mentioned earlier on to the deputy convener, of the commission that had brought about the gap analysis of the freedom of the fairness at work process had identified even then that there was an inconsistency about how we were dealing with complaints or concerns against ministers. So it was not prompted by the 2016 People Survey, though bullying and harassment was an important part and therefore an important context for subsequent work and the subsequent commission that came up in October.
You indicated that some areas of government came out of the survey differently from others, let's say. I appreciate that within the rules that there's a limit to how granular you can be in the answer to this question. But can you say more about what areas of government were highlighted in the survey? What work of government, let's say, was highlighted in the survey more than others?
In the 2016 survey? Yeah. I could probably give you better written advice than I can off the top of my head on that. But there is always, in all of the... so there are some themes that are always ones which we look most closely at. One of those is bullying and harassment. The other one is managing change.
Sorry, I mean, which parts of government?
Oh, sorry, you're talking about which specific. I would probably need to come back to you to give you, but we have plenty of data on that, and I'm very happy to give you an analysis of that particular year, that snapshot of that year, yes.
And finally, I again alluded to before, but there were, following that survey and following that initial analysis of it, what might be called, vaguely perhaps, interim measures. A director appointed, somebody described as a sounding board. Was any assessment of the effectiveness of those immediate measures for creating points of contact for staff undertaken to assess whether they were, let's say, sufficiently formal?
I think there are two different elements to your question, I think, Dr. Allen. The first is that a sounding board, confidant, I think that's the term that was has been used as well, was part of the procedure for the 2017 procedure. So quite separate from anything to do with the people survey. But you're correct in that I appointed a senior director to look specifically, as I mentioned earlier on, to address culture and to produce some research on culture about what made a difference to people feeling more comfortable about raising bullying and harassment in particular, what the circumstances are would make them feel more confident about raising that. And that information was very helpful because it was used as a backdrop to support and advise all our SCS leaders. They were given professional advice and research evidence on causes and cultural conditions associated with bullying and harassment, and particularly asked to get under the skin, as I would call it, of their bullying and harassment scores locally as a result of listening and hearing about that research. So what to look for.
Thank you, Convener.
Thank you. Can I note at this point, thank you for your offer of written evidence, and just to make very plain that there would have to be great care taken before that kind of evidence could be submitted to the committee. Thank you very much. Now, I understand Alec Cole-Hamilton had a specific point in relation to this, and we'll follow that with Murdo Fraser.
Thank you very much, Convener. It's a very specific follow-up because I want to reserve the bulk of my time for questions about the timeline of events around the development of the policy. Good morning, Permanent Secretary. Any organisation where 65% of complaints went unresolved, staff would understandably not have a great deal of faith in the existing processes that went before. So I just want to ask about the informal ways of handling complaints. Was it a commonplace in the culture of the government for teams to be, for managers within teams, say, for example, to change rotas, to change working locations, or to change specific duties so that complainers were further removed from subjects?
Particular period of time?
But prior to this new policy coming in, yes.
So prior to 2017?
Yes.
I'm not aware of it, and it's certainly not something that I would encourage. I think that managers are supported, and we have a management development programme, as you would expect any organisation to have. They're supported in their own right as managers, but also through our HR expertise to be able to resolve things locally where they can, but that is not by avoiding the issue. That is about taking preventative wherever possible, but appropriate steps to resolve. And wherever possible to do this informally. But there are some clear circumstances where informal resolution is either not appropriate or not going to, it fails.
Can I move on to Murdo Fraser, please, and then we'll hear from Angela Constance and Jackie Bailey.
Thank you, Convener, and I'd like to ask some questions as a follow-up to this issue of organisational culture, and specifically to Margaret Mitchell's questions a few moments ago. Permanent Secretary, you'll have seen that we had a submission from the FDA, who are the trade union for senior civil servants, to the committee. I'd just like to read just a couple of short paragraphs from that. And they say this, and they're referring to the publication of the Fairness at Work policy in 2010. And they say this, around this time, the culture within the former First Minister's office and other ministerial offices in relation to bullying behaviour became a concern for us and was raised with successive permanent secretaries. Although action was taken and short-term improvements or apologies were made, this did not bring about an overall change in culture. Some civil servants expressed to us that they were operating in a culture of fear and were unable to speak truth unto power and discharge their duties effectively. The culture within the ministerial offices in the organisation was such that despite the support of FDA, some members made it clear to us that they did not trust SG to handle complaints effectively or to ensure confidentiality of the complainants. They furthermore expressed concerns over the effectiveness of the policies at that time. In particular, members in the former First Minister's office indicated that they felt isolated and out of the policy protection of the rest of the Scottish Government. Individuals spoke in confidence and did not wish to raise complaints because they thought that this may be detrimental to their career aspirations or their current role. Now, I'm sure you would agree there are very serious complaints that have been raised by the FDA. I appreciate you only became Permanent Secretary in 2015, but prior to that you were with the Scottish Government in a senior role. Were you aware of these concerns that have been highlighted by the FDA at that time?
I read the FDA's submission with interest. I don't recognise the term culture of fear. It's not one that I would use. I think 2 points really, well, 3 points actually. I mean, firstly, I will come back to this. I'm glad I don't recognise some of those terms, and I am not complacent in any way, and I really do want to stress that. But the most recent snapshot of how the organisation is feeling is very different to what the FDA has described in historical terms, and I'm pleased but not complacent about that. And so we have compelling data to show that people are willing to come forward now, are happy with the levels of inclusion, but it is not perfect. So I'll put that to one side, but that is the context in which I'm making other comments. The second point is that I was aware that there has always been aware that working in any private office is full of strain, stress, hard work. We have many people around the table this morning who have been ministers and will recognise that the description of private offices being a very difficult place to work, and that is one of the reasons why I instigated additional support for private office, and indeed we've strengthened the pastoral care I mentioned earlier on to ensure that staff did feel supported and did feel that they knew where to go when they were feeling, if they were feeling uncomfortable or felt that they had problems with their workload and so on. I would say also that whilst I don't recognise a culture of fear, I do think that we have worked closely with the trade unions during my time as Permanent Secretary to ensure that where they have concerns raised with them, where they have people, membership going to them with issues or complaints to make, that we work closely with the trade unions through our HR team to ensure that where people feel they want to make those official, in other words, come to the organisation rather than through the trade union, though they are absolutely at liberty to do that, that we would encourage them to take that path. So anecdotal evidence is important, but we also need people to come forward formally. And I suppose I would finish by saying one of the things that I have been at most pains to do as Permanent Secretary since 2015 is indeed to make it clear to the organisation that culture is paramount. And to use one of my phrases, what you permit, you promote, and that we should call out areas of poor behaviour, anything which makes people feel uncomfortable or lacking in confidence in being able to bring themselves, their full selves to work. So I'm very fixed at the moment on where the organisation still needs to address issues. Changing a culture does not take months, it takes years. And I'm not complacent, but we have got a more inclusive culture than we did have. We have greater capacity, and we have built staff confidence to come forward and in the knowledge that action will be taken. That is still work in progress, as I said in my opening statement, but it is certainly something which I have made an important part of my leadership contribution as Permanent Secretary since 2015.
Okay, thank you for that response. I understand the point you made. You feel things have got better, and you also said you don't recognise the term culture of fear. We will be taking evidence, I think, next week or the week after from the trade unions, and we'll get their side of the story. But just to put this to you again, they say that their concerns about bullying behaviour were raised with successive Permanent Secretaries. Were they raised with you?
I don't remember ever being given a specific complaint from a trade union about a specific bullying behaviour. Having said that, I'll hastily make sure that I'm thoughtful about this response. I can't comment for previous permanent secretaries. We have had cases addressed at an informal level of bullying and harassment against ministers. 2, I think, since 2007, but I will check my facts. And I know that the unions have raised regularly with, and correctly and rightly, with HR colleagues about the nature of the culture being addressed so that people feel they can speak out if they are exposed to bullying and harassment. I am aware of concerns raised in the past about certain behaviours. I cannot say other than that. That's based on confidential conversations, and I prefer not to say more than that. But during my time as Permanent Secretary, I have seen this as a point of principle and great importance for the organisation to improve its culture, develop its culture to be more diverse, more inclusive, and as a result, more able to demonstrate the importance of equality policies that the Scottish Government embraces, not just for the organisation, but for Scotland as a whole.
Okay, thank you. And one final question, Convener, if I may, at this stage. It has been stated publicly that female civil servants were advised not to be alone in the company of the former First Minister. Is that something you were aware of?
I can't comment on that.
At this point, Mr Fraser, I'm not sure that's entirely appropriate at what we're doing with this committee under the remit.
Well, I think, respectfully, I think it's a relevant question in relation to the culture we're trying to investigate, which led to the development of the policy. The Permanent Secretary said she cannot comment. I don't know if that's a denial or an admission.
Mr Fraser, I've made my decision. And
okay, thank you, Convener.
Point of order, Alex Cole-Hamilton.
Thank you, Convener. Just, I agree that I believe that Mr Fraser's question is pertinent. I think this committee is charged with looking at the government handling of harassment complaints, and that doesn't just mean the application of hard and fast procedures. It's also the application of informal steps that were taken to protect complainers. And I think that if that is something that happened, it's absolutely something this committee deserves to know about. Mr
Cole-Hamilton, I've made my decision. And this is something that the committee can discuss in private if they wish to. And I'm more than happy to listen to all committee members' views at that point.
Legal advice on this. We've got the the Permanent Secretary in front of us. That maybe she's quite willing to do it. If not, could we take
Can I just say to the committee that I have made my decision, thank you, and we will discuss this after the meeting when we're in private session. I am willing to listen to all committee members. I am willing to listen to the Parliament's legal advice on this. We will take a decision, and it may well be that we could invite the Permanent Secretary to either give evidence in writing in this regard if we take that decision, or indeed for the subject to be raised again if she comes back to speak to this meeting. Meanwhile, I think we should move on. And I call Angela Constance to be followed by Jackie Bailey.
Thank you. Good morning, Permanent Secretary. Complaints need to be investigated and policies need to be fit for purpose. So why was there no wider, more formal staff engagement other than an email from yourself to all members of staff, the 2nd of November 2017, document YY004?
So I think if you're referring to the procedure and the development of the procedure, I was informing staff that the procedure was under development. It was an employment procedure. It was one where we were engaged with the unions and we were using, as part of the commission from the Cabinet and indeed from Sir Jeremy Hayward as well, we were asking the lead division most appropriately tasked and most appropriately skilled to undertake that procedure development. So I was alerting staff to the fact, if I'm correct in recalling the document, I was alerting staff to the fact that we'd been commissioned to produce this procedure and that it was underway.
I understand the content of the email. I suppose my question was about where were the more formalised engagements with staff, but I do want to come on to trade union engagement as well. The Scottish Government's written statement, chronology of events, lays out the background to the policy development, which is what we're discussing today, states, you know, what took place 2016, spring 2017, and that's clear. In your opening statement, Permanent Secretary, you spoke about how the Me Too movement gave momentum to the work around this policy, and you referred to the instructions that you got from the First Minister and Cabinet. What I want to ask you about is the pace of that work from beginning of November until its completion, which was either when the First Minister signed it off on the 20th of December 2017, or when the policy was finalised in January before it was published in February. And I wonder if you could say what informed the process, you know, why was this work done at pace, given that the trade unions acknowledged that this policy was developed quickly. Given that, and forgive me if this is a stereotype, given that civil servants are known for their strengths in methodical and forensic work, sometimes maybe at the expense of doing things at pace. So I'm keen to understand why this work from the end of November till it was completed was done at pace.
Okay, so the commission was from the 31st of October, so under Cabinet Commission, though, as you will know yourself, is an important piece of work. A commission come directly from Cabinet has a particular status associated with it. That is endorsed or was endorsed and enforced by a letter from my line manager and head of the UK Civil Service, Sir Jeremy Hayward, who asked all permanent secretaries, satisfy yourself rapidly that processes are in place. So we had a Cabinet Commission, which has a status associated on its own, and we have the head of the UK Civil Service writing out to every permanent secretary in the land saying, satisfy yourself. We also have, we knew the unions were keen, and we've spoken about this, to ensure that any issues of harassment were addressed and taken a strong stance. I think that's to use their term. So the setting also, as we said earlier on, was against quite a febrile atmosphere in terms of social media, but also some very high profile and very high-hitting examples of historical harassment and current harassment. The Scottish Parliament was not immune from that. So I would hesitate to say it was rushed. I don't think that's accurate. I think it was an intense piece of work, and it was a very focused piece of work. And it was located in the right part of the Scottish Government, in the heart of the Propriety and Ethics and Ministerial Code team. And it was iterative. And you will see from the paperwork that we have provided, and subsequently as well, if you speak to the Deputy Director who led on this piece of work, it was highly consultative within the organisation, and indeed drew on guidance from ACAS, and we also spoke to Police Scotland about it. It was not self-contained within one division, so it needed a fair amount of coordination as well, and it was informed at every stage by legal advice and by HR expertise. So I wouldn't say it was rushed, but I'd say it was intense. And by the time we came later on in that year to bring the complaint, the procedure to fruition, and to ensure that the First Minister, who is the ultimate arbiter of the Ministerial Code, needed to be satisfied, and I were happy with it. and that also the trade unions were comfortable with it. We also had a number of people who were raising concerns at that point, not complaints, going back to my previous differentiation, but concerns. I did not know whether those concerns were going to turn into complaints or not, but it was a reminder that this procedure was required, that we had acted appropriately, and that we needed to make sure that we had a robust and professionally well-researched procedure ready if people decided that they wished to lodge formal complaints. And that was an important word, if they decided to do that.
And, Permanent Secretary, can you confirm when this policy was signed off? Again, the Scottish Government chronology of events refers to the First Minister signing it off on the 20th of December, but it was not published until the 8th of February, and there appears to be a bit of to and fro with feedback that was received from trade union colleagues on the 19th of December, and it's not clear whether those comments were, whether the policy was adapted to reflect those comments or not. So I'm just keen to understand when the policy was finalised, done, signed off.
So it was signed off by the First Minister, as I think you've seen from your paperwork, on the 20th, that's correct. It wasn't published immediately because there was other relevant work ongoing, and we wanted to bring the whole package together. So 2 elements in particular. There was still some, my understanding was I wasn't closely, as you would imagine, engaged in this, but there was still some fairness at work discussions with unions were ongoing at that point about how you would define and refine the fairness at work policy in relation to this procedure. So that was one thing. The Ministerial Code, the Scottish Ministerial Code, was being revised to reflect changes in the UK Code, and we wanted to bring that in all together so that there was a neat and coordinated approach to publishing the procedure, the changes to the Ministerial Code, and that we had concluded discussions on the fairness at work with the unions. So the unions, of course, were already aware of the procedure in December. So had complaints been lodged at that time, for example, they would have known what the procedure required and was what was associated with it. But we published at that time in February, where we had all the other pieces of the jigsaw, if you like, in place.
Okay, thank you. And my final question, just now, I may wish to come back to some further issues in and around trade union involvement, but I really wish to understand more, Permanent Secretary, about what informed the decisions around sharing a policy when it was still a draft. So, for example, again, we know from Scottish Government chronology of events that the draft policy on the 14th of December 2017 was shared with a potential complainant when the policy itself wasn't signed off by the First Minister till the 20th of December.
I understand that too. I wasn't aware because I wasn't close to the procedure development, as you would expect. But I would make 2 points on that. First of all, it is not unusual. In fact, it is increasingly the case that in developing policy and procedure, we base it as much as possible and draw on what is called, not a term I particularly like, but it is a term that is referred to as lived experience. So in drawing any policy together now, in order for it to have resonance and relevance, it needs to be not at the pen of a civil servant, but actually reflecting what people are wrestling with in their own lives, experience, and so on. So that would have informed that procedure if somebody had raised a concern, and a number of people had raised concerns by this time in November. It wouldn't have been beyond professional practice to have asked about that. But more particularly, and I think more importantly, the other issue is to ensure that the developing procedure, would it have made a difference in different circumstances? So in other words, this isn't about the future, this is about what could prevent in future, something that was in a procedure that would mean that the experience that people might have been telling us about would have been less likely to happen. Final point on this is my understanding was I was also informed that it was shared on the 14th of December. That was the time of the final draft. I think it was version 7, the iteration was at that point, and I don't believe that there were any changes made as a result of that sharing either. But that is not an area of expertise of mine. That is the people who were developing the procedure at the time, and I'm sure you'll be talking further to them.
Jackie Bailey, to be followed by Alex Cole-Hamilton.
Good afternoon, Permanent Secretary, and let me make a very gentle correction before we get going. I think you said that in your opening statement that the committee had been provided with all the evidence they sought to the timescales we asked. I think you'll find that's not the case. The committee have sought information that they've not been provided with, and certainly not to the timescale requested. But I accept that civil servants are busy with other things. I just think it's important that there is accuracy. Can I move on to my first question? Well, indeed, but let me ask my first question, and you can do so. Cabinet Office has expressed concerns about the policy to include former ministers in an email, and that exchange is captured at YY092. Comments made where the Cabinet Office expressed disquiet. They asked you to await their review. Did you do so? And was there any further contact with the Cabinet Office? Because clearly the policy isn't signed off.
So the Cabinet Office doesn't need to sign off the policy of the Scottish Government. I think the first thing to point out, though we have regular contact and good contact with the Cabinet Office, as you would expect, the responsibility for developing employment policies and procedures for staff is delegated to the First Minister for Scotland. So we take our instruction through that, and of course I act on that behalf. So we're working to a commission by Cabinet, and also coming from quite a different place to the UK Government and the way that they operate. They don't have, to my knowledge, a fairness at work policy. We did have flawed, but we had it, a written procedure to deal with bullying. So we were very clear about the sensitivities relating to our own circumstances and our own understanding and commission from Cabinet. Cabinet Office discomfort in these areas is not new. They are and have wrestled with their own concerns about procedure. They don't, I believe, at the moment still have a written procedure. I may be corrected in that, but I believe not. They don't have a published policy for handling cases involving complaints about ministers. And I think it is held, these issues are addressed to their propriety and ethics team using the Ministerial Code alone.
Wait for their review?
So the review... Was
there any further contact beyond this?
Yes, apologies, I didn't address that point. So the Policies and Procedures review that Sue Owens was undertaking in January was quite separate and distinct from the policies that we were pursuing, and they also were separate because those are delegated to the First Minister. We did actually take notice of that because, of course, all this stuff is generically relevant, but it wasn't something that we were partaking of.
Thank you. So there was no further contact. That was the email exchange, but you were aware of their review in January after the thing had been signed off in December.
We were aware of their review, and we continue to have contact with the Cabinet Office. We always do. Great.
Can I explore something that Angela Constance raised? And just so I've got this right in my mind, you published the new policy on current and former ministers on the 8th of February. Is that right?
Right, yes.
On the website. Okay. Yet you had complaints lodged in January. Am I correct about that?
That's correct.
Okay. But you said in a press release on the 23rd of August that you'd publish the new policy and procedures on the intranet in December. Surely that's not correct, given what you've just told me.
I don't recognise that, so I would need to go away and check that. But no, it was published in the on the internet in February, having been signed off in December, for the reasons that I gave earlier on. I'm happy to clarify if I was confused or if that is a different reference.
But the policy, was it signed off, given that you were making amendments in January?
We didn't make, to my knowledge, I don't think there were any further amendments made in January. Okay. It was signed off by the First Minister and myself on the 20th of December, having had consultation with relevant parties. I think the work that we were referring to earlier on was the fairness at work policy, where there were still discussions taking place with the unions. And indeed, we are still talking to the unions about the fairness at work policy even now.
Is it customary, forgive me, I don't know this, for people to lodge formal complaints about a policy that hasn't yet been published for the civil service?
So I think what's important here is that people will decide to lodge complaints at any time. They don't need to or feel, I'm sure, the necessity to wait until a procedure is in place. We had concerns raised during November, many of them, some translated into complaints, and the individuals who decided to do that did them in January. They could have done that at any time. I wasn't aware of why their timing was then, but we had a number of concerns, 2 of them translated into complaints, and those were lodged in January.
So, of the concerns you had, you're saying 2 were then lodged in January. Was the information on the drafting of the policy shared with those 2 people prior to them lodging complaints?
I believe that one of the people who went on to lodge a complaint, as I was referring earlier on to Ms. Constance, did offer views on, was asked in terms of lived experience about the draft as it was then. I wasn't aware of that. It is not unusual to test out new procedures or policies with people who have relevant experience, as I mentioned earlier on. But there was, I don't believe there were any changes made to the policy as a result of that, and it was already at version 7 by that point.
Okay. Thank you. I'll reserve my other questions for after convening.
Okay. Alex Cole-Hamilton, then I think Alison Johnson had indicated she wished to come in.
Thank you very much, Convener. I have 3 specific questions. The first is a double header. Can I ask Permanent Secretary, given that the original procedure was designed to cover the whole of the civil service, why did the expansion of the policy on retrospective harassment only extend to former ministers and not former civil servants? And why didn't it cover non-harassment complaints as well?
So the answer to that is that civil servant to civil servant complaint is covered in the Fairness at Work procedure. And so is, sorry, your second question was?
Only harassment complaints and not non-harassment complaints.
Right, so
as well.
bullying, which would be the counterpart to harassment, is covered by the Fairness at Work policy. So I think what we have to understand here, and as I said, I was not involved in the detail of this, is the clarification and the improvement of the Fairness at Work, particularly where there had been issues, as I referenced earlier on, where trade unions and others have said it's not working very perfectly. This was the opportunity for us to clarify what policy does what. And so for harassment purposes, the 2017 is the go-to place. For civil servant to civil servant, it is Fairness at Work, and for bullying, for ministers, it is Fairness at Work. So that is the rough divide that we use for referencing the policy and where it's applied.
Thank you for that. It's a matter of public record that Miss B first notified officials of her complaint against Alex Salmond on or around the 7th of November in 2017. That was at the height of the development of the policy. She asked that you be told. Did you at any point signal to either Nicola Sturgeon or anyone else involved in the development of the policy, as it was for former ministers, that this complaint had been made?
So a concern was raised by a whole range of people in November 2017. And I think what we need to bear in mind here that there were 2 or 3 elements going on at the same time. There was a procedure that was led by a deputy director in charge of Cabinet, Parliament and Governance Division, drawing on others' experience to produce a procedure in response to the Cabinet Commission and Sir Jeremy Hayward's Commission. At the same time, and as a backdrop with Me Too, historical high-profile cases taking place, we were receiving concerns from staff, and that was in a separate but concurrent stream of work which HR team were undertaking. That is providing support, advice, information for staff. And on my request, a confidential sounding board post was also added to that, so that people who did not want to go to HR, did not feel the need to, could go to this confidential, similar to a phone line, which I think is what the Scottish Parliament set up, but actually a live person to say that they needed and wanted to have some reference. So I was made aware of 2 things, actually. I was made aware of contact that had taken place between Mr. Salmond and certain Scottish Government members of staff in very early November. He had contacted them because he had he wanted to talk to them about a piece of media work that was going on, which was being held, undertaken by Sky News. And I was told by two different sources, one of them extremely concerned, that they had received this contact and they were a bit bewildered and unhappy about it. I didn't know what was said, I didn't ask, I didn't feel it was appropriate to know, but I was concerned that the staff, and they are always my priority in these sorts of circumstances. So I mentioned that Mr. Salmond had been in touch with staff about an Edinburgh Airport incident that Sky News were investigating, and I did mention that to the First Minister. I told her about that. I said I was concerned. I was concerned mostly because the staff were anxious about it. I was also concerned that it could become a story. I didn't know, and I was concerned that we would be ready in whatever form that story might blow, because the media was very volatile at that point and reporting on everything. At the same time, I was told that there were other people who were coming forward with concerns, not complaints. So concerns, they were not registered. And I'm looking around here to see if the convener is comfortable with my response.
I'm in danger of becoming uncomfortable.
Okay.
Can I draw it back? And just
yes,
before
I would
ask my
appreciate
final
it, please,
question,
Mr. Coham. So I could draw it back.
if I could just draw it back to specifically Miss B, who raised the complaint and explicitly asked it only be shared with you. Did you
recognise that at all? Actually, that's not my. I don't recognise that
so
at all.
you don't have a recollection of that, but
I don't have a recollection of a Miss B asking for a complaint to be shared with me. I have a recollection of a concern being
Can I
raised.
stop this here? I'm becoming concerned again. That
move
wasn't
on.
pulling it back.
Okay, I'll move on.
So can I ask both committee members and indeed our witnesses to be very, very aware of the remit of this committee and the constrictions under which it works. So please, if you would genuinely pull it back, please.
My line of
Mr.
questioning is
Coham.
entirely concurrent with our remit,
Thank you.
Convener. I will ask my final question. So we know that a specific policy on former ministers was in train between October 31st and the end of November 2017. Miss B's complaint emerged at the start of that process. I guess what I'm trying to get to was the knowledge of that, which was known by some officials who had responsibility for designing the policy. Did it influence the design of that policy or in any other way? And forgive me for being blunt, just to put it another way, but the optics of this are not great. Was this targeted policy, which only applied to harassment complaints against former ministers, engineered to fit any complaint that had been arrived at through the Scottish Government?
No.
Was it designed to get Alex Salmond?
No, absolutely not.
Okay. Thank you. I understand Alison Johnson has a specific question.
Yes, thank you, Convener. It's with regard to the development of the process for current and former ministers and your confidence in the independence of the process for the investigation of complaints against ministers. And in an email that you write to senior trade union officials on the 8th of January, you note that the procedural flaw in the investigation relates to the perceived impartiality of the investigating officer, and that there is nothing to suggest that the investigating officer did anything wrong. So I would just like to understand the point that you make here, because the trade union prospect, they note that you explained, the Permanent Secretary explained, the decision taken by the Scottish Government to concede the judicial review taken due to an issue with the application of one paragraph in the process. And I think earlier on in your statement this morning, Permanent Secretary, you spoke about one part procedural failure. I'd just like to understand exactly what that failure was and why it happened.
Okay. So we're in danger of getting into the sort of judicial review and the implementation, but I absolutely understand the premise of your question. So if the convener is happy, I will answer this. The meaning of paragraph 10, which is to do with the role of the investigating officer, was absolutely clear to those who were involved in developing and indeed in the operation of the procedure. It was very clear it was that the investigating officer should not be involved in the matter being investigated. That's the terminology of it. Now, previous iterations of the final draft are absolutely clear about the other elements of the investigating officer that could comprise that. But we simplified it, and it was summarised in not involved in the matter investigated. But it is worth looking at previous versions of it, which gives much more detail about what the investigating officer or the IO role was really about. So it featured in earlier drafts, but what became clear during the process of the JR was that this paragraph could be open to a different interpretation. And that was the point on which we conceded. It was the acceptance of apparent bias, not actual bias in the way that the investigation was carried out. And that's a very important point. So in other words, the different interpretation was that not just that the investigating officer should not be involved in the matter being investigated, but have, in addition, this was the JR's interpretation, that the investigating officer should have no prior contact with the complainers, as well as no involvement in the subject matter of the complaint. So I hope that clarifies the differentiation.
Yeah, no, certainly. Yeah, so there will be lessons learned from this occurrence.
The application of the procedure, absolutely, and the Dunlop review, Laura Dunlop, which I mentioned in my opening statement, will take into account and will focus predominantly on this element, on the interpretation of that paragraph and how we may need to make it clearer in terms of how it is applied in the future. So not the procedure overall, but the application of that one element, yes.
Okay, thank you. Thank you, Convener.
I think it's appropriate now to move on to Maureen Watt and Jackie Bailey.
Thank you, Convener, and good afternoon, Permanent Secretary. We've already spoken about the fact that in spring 2017, a director was appointed within the Scottish Government to champion tackling bullying and harassment. Can I ask how that person was chosen, who it was, and what qualifications did that person have for this role?
So it was an experienced director, a director who was at the time, I won't give names if that's all right, but it was somebody who was had moved their way up and around the Scottish Government, so familiar with the culture of the organisation, had worked in a range of different policy areas, and who was a generic manager, therefore somebody who had been in the position of many of our managers of looking at their bullying and harassment scores and thinking, what do I do about this? So they were to lead that piece of work. They were well experienced to look at it from the perspective of practical application of the knowledge that they were going to bring about. And they were working very closely with two specialists in the HR team. So they were working as a small unit to look at what do we need to learn about how culture changes, and particularly what are trigger factors for a culture of bullying and harassment.
So why was it not just somebody from the HR directorate who would have a qualification in personnel management and development?
They were working to and with that individual, but I wanted to have somebody, two things. I wanted somebody who had already had experience in receiving people survey results year after year and looking and deciding what they did with them and how they used them to best effect for change. So somebody who was in a director's shoes in this position. And secondly, I wanted somebody who had worked across the organisation and who also knew how to work in a team with people with specific expertise. And I think it worked well. It was something that I'd introduced that had never been done before. And I think the other thing was that other directors and other managers listened. That's not to say that they wouldn't, of course, listen to HR specialists. They do, and we draw on that HR expertise every day of our managing lives. But I think when you're faced with somebody who's in the same position as you, maybe responsible for several hundred staff, working under pace and duress, then I think when you're listening to somebody who has been in the same position as you and who is interpreting the data and the analysis from your perspective, I think that helps. And I wanted to make sure that senior managers were listening to this and looking at their own results through the lens of experience that they recognised.
You said earlier in relation to a previous question that people might not want to go to HR. In any other organisation, I would think, first of all, you might go to your line manager if that was appropriate. But if it wasn't, HR would be where you would go.
Yes.
Why do you think people don't want to go to HR in the civil service?
Well, I hope that's not what I said, though I understand the line of questioning that you're putting to me. I mean, people will go to a range of places. They will go to their line manager, they will go to their union, and they will go to HR, and people do. Regularly. So please don't let it be put on the record that HR are not doing a good job and that people aren't going to them. The very particular circumstances where I appointed a sounding board, what I referred to earlier on as a confidant sounding board, was during the period of the autumn 2017. That was unique to those circumstances. It was somebody that I thought could act as a complement to HR, where people felt they wanted to go to HR and share their concerns and ultimately may decide to make them into complaints. They could go to HR, of course they could. Frequently what people wanted, and this is borne out with research, and you will be very familiar with this, I know, in the work of this committee, or increasingly so, people don't necessarily want to go to the official place. They want to go and have somebody just understand what they are saying, what they've experienced. They want somebody who will listen and who will point them to points of further information and help, but who will just recognise the experience that they want to share. Many people, we found, did not want to take their experience of poor behaviour any further, but they did want somebody to listen and understand, and they wanted it to be registered. And that's what this particular and unique role was about, for a very unique set of circumstances against the backdrop, as we know, of the hashtag #MeToo campaign.
So, do you feel that the role set out in the policy for senior figures was and is sufficiently clear to meet best practice standards? I mean, who, for example, would take a decision to alerting the police where a crime had been committed?
So we took advice on the police point particularly. Well, first of all, in your first question, yes, I think the roles in the procedure are clear, though we will learn from the Laura Dunlop review, which I intimated earlier on to Ms Johnston. So the Laura Dunlop review will be looking at the application of the procedure, and if there needs further clarity, of course I will be particularly keen to ensure that we put that into place. With regard to the police, the point here, and we took advice from Police Scotland on this, we wanted to ensure that the procedure was appropriate and sympathetic and effective in terms of encouraging people to use the procedure. As I said earlier on, it's an employment procedure, not a legal tool. And the police's view, and one that we adhere to and is reflected in the procedure, is that this must be led by the victim, by those people who are bringing concerns or complaints. So if they wish to go to the police, they are at liberty to do so at every stage in the operation, and would do so. It expressly stipulates, I think, in the procedure that staff are free to make a complaint directly to the police at all times. And the confidential sounding board post I spoke about earlier on also emphasised the importance that if a victim felt that a criminal act had been committed, or that they felt that they wanted the police to know, it was entirely appropriate for them. However, as our investigation, which I know we're not going into the application of that now, but as that reached its conclusion, the Scottish Government decided, informed by legal advice, that 3 of the complaints should be referred to Police Scotland. And of course, as a government, and indeed as a member of the civil service, we have to comply with the law.
Okay, thank you for that.
If you could quickly, Maureen.
Sorry, I'm keen to tease out, if I can, the level of oversight of the Cabinet and executive team in the development of policies, not just the harassment policy within the government. So, for example, I would take it, you know, if you're recruiting to the legal directorate, you would look for people with a legal background, similarly with finance. In terms of HR, is that the same procedure, or is it the idea that the civil servants are able to do anything and everything and they're slotted into HR? Do you consciously recruit people with an HR background?
We have and we did, yes.
Okay, you know, you've got the day-to-day running of a civil service, which is an organisation which serves ministers. Is that very separate, apart from where there's an overlap, for example, with the harassment policy to the ministerial code, which is a place where it is an overlap? Is it otherwise pretty separate? Or does the Cabinet get papers in relation to lots of organisational matters?
Yes, no, Cabinet does not receive papers at all on organisational matters of the kind of HR and so on, unless it is a procedural issue or a change of procedure, but not in terms of the content of those. That's not traditionally undertaken.
And in this case of the harassment policy, I understand that the First Minister asked the DFM to get involved. What was his involvement?
My understanding actually of his involvement was very limited, and I think it was, if I recall it correctly, it was discussed at Cabinet when the Commission was created, that it would be appropriate for a man to instigate the PQ, the parliamentary question, which prompted this in response to exchanges, of course, between the First Minister and the presiding officer, who had already had written exchanges about the importance of this issue. I think it was agreed that it would be good for a man to instigate this rather than a woman, which could be considered to be a bit stereotypical. And I think the DFM was asked by the First Minister if he would do that, or I think actually he volunteered to do that. My understanding was that was his only involvement in the development of the procedure. Ministers wouldn't be involved in the procedure or development at all.
Okay, thank you.
Jackie Bailey.
Thank you, Convener, and I will try and make brief questions for brief responses. Again, you said to Angela Constance in this area that you started work on the new policy, but can I ask you, the inclusion of former ministers, that wasn't mentioned in the parliamentary statement on the 31st of October, nor was it discussed at Cabinet on that same date. Is that correct?
It wasn't specifically discussed, although the context of the Commission actually did refer to the fact that many of these are long-standing issues. So it was clear that there was a context there.
Okay, but it wasn't specifically mentioned. At what point were former ministers mentioned and by whom?
The first iteration of the policy. It's my understanding. I don't have it in front of me, and others were closer to it, but I go back to the previous conversation where the fairness at work procedure failed to mention past ministers, and it was a gap that had already been identified.
So the first iteration was James Hind then?
James Hind was responsible for all the iterations.
Okay, so he was the first person that introduced it, not in conversation with anybody else?
Not the mindset. Well,
okay. Well, I'll ask him that. It's fine.
No, can I just clarify?
Okay.
James Hind was and is the person who's responsible for the Ministerial Code and ethics, so he led on the development of the procedure. He will have had conversations, of course, with others, legal particularly, but also HR. But from the first part of the first draft, I believe, it mentioned previous.
Okay, thank you. Did you seek a view, you mentioned lawyers there, did you seek a view from lawyers within the Scottish Government about the overall policy and specifically the inclusion of current and former ministers?
Throughout the iteration of the policy.
And did they express any concerns?
I can't answer that because obviously lawyers were involved throughout. They will have expressed views and given legal advice throughout the iteration from the beginning of November until the 20th of December.
Is it appropriate for you to go back and consider whether they express concerns for the committee?
I suspect this will fall under the legal privilege. And I don't have any locus on that, as you know. That is a ministerial decision.
Sure.
And
the Deputy First Minister did say we could ask, but we'll maybe pursue that elsewhere.
You're welcome to give me written questions, of course.
Yeah, could I move on? Judith McKinnon, in a memo dated 7th of November 2017, I think that might be YY073, suggests that allegations against former ministers should be escalated to you, but that someone independent should investigate complaints. I think that view was shared by the trade unions and by James Hind, but you never implemented it. Can I ask why?
So my point about independence was slightly different from the union's point about independence. My point about independence was actually about how somebody might be slightly aside from the HR process in the way that I've just described to Miss Watt on the confidential sounding board. So somebody could be within the organisation, but aside from HR, who could act as a confidential sounding board. The issue about...
specifically to former ministers?
No, not my point, and I don't recollect that being particular to former ministers. It was to do with the procedure as a whole. Okay. I think the point that has been raised subsequently about independence, and particularly I think by the unions, is whether or not there should be a more independent element inserted within all procedures. And I think that has taken place subsequently with the Westminster procedure. There is now an independent element within the Westminster procedure.
Okay, can I then move us on to the letter commissioning the policy to include former ministers was sent to you by the First Minister on the 22nd of November. Can I ask you when the Chief of Staff was involved? Was it before that date?
I can't tell you, I'm afraid. I wasn't involved in the drafting, so I don't know. But we already had included former ministers in all the iterations that I'm aware of former ministers, because it was there from the very beginning.
Okay. So do you know when the Chief of Staff became involved? Because you say that at paragraph 27, the only involvement was about the allocation of responsibilities between the First Minister and the Permanent Secretary, and provided comments on a draft of internal correspondence. Is that paragraph right?
I can't comment on it.
No, you've made that in your statement.
Well,
I'm asking you if the paragraph is correct.
Well, I'm not quite sure the point we're trying to get to here. The point about historical allegations against previous ministers was in the very early iterations as a result of work that had been done on the fairness at work policy. It was confirmed in the letter that the First Minister sent in, I think it was sometime in November, 22nd of November, I think is her letter, sometime around that, where she was confirming elements of the procedure and where they would apply. I was not involved or engaged, and nor should I be, in the toing and froing of different parties in how that was the procedure was drafted. That's not my role. So I'm afraid I would need to refer to other people about when and how individuals were incorporated and consulted.
So you never had discussions with the Chief of Staff?
I do have discussions with the Chief of Staff.
Okay. About this?
I don't
Prior
remember.
to the letter on the 22nd of November
I don't recall
being signed
having
off?
Specific, but I have discussions with the Chief of Staff on a whole range of issues, as you might imagine. I don't remember having a particular discussion on this, no.
Okay. Well, that's unfortunate. Okay, because you assert quite clearly that the Chief of Staff only had one specific comment to make.
Well,
and
that may well be the case, yes.
And but you can't remember if there was any other discussions around about that time.
She wouldn't necessarily make it to me. I wasn't drafting the procedure. That's not my role. That was delegated very clearly to the Deputy Director, as discussed earlier on. So it may well be that there were discussions took place, and it may well be, as I've said, that was her contribution, but it wouldn't be
So
to
you
me.
can't say accurately that that was the sum and substance of her contribution to this issue, other than you have no recollection that anything was said to you personally?
Well, I can only take account for what people have said to me personally. I have no
I'll pursue this
recollection of
with
that.
others.
particular-
Thank you.
My memory, it's nearly 3 years ago, may be wrong, but we would have had conversations about a whole range of things during that time.
Memory is a fickle thing. Let me ask you one thing very personally. When were you made aware of the likelihood of concerns or complaints made against the former First Minister?
So we're going back to the conversation I had with Mr Hamilton. I was first aware of the issue being raised through a different route, which was Mr Salmond getting in touch with our staff.
Okay, you don't
about
need to
Edinburgh
repeat
Airport.
that.
After that, I was made aware of a range of people, but I didn't know who were raising concerns. They were raising concerns about a range of different circumstances. I understood, but I wasn't told about them. And one of those I was alerted to had referenced Mr Salmond.
When was that?
That was in early November.
Okay.
Now,
Convener, I have
then
one final question, if I may, very quickly.
I would ask you to be circumspect about it.
Absolutely, it's not on this. I'm going to take us to a different
you.
place. I understand that James Hind, who was responsible for drafting the policy, is now assigned to the Ministerial Code investigation. Do you consider that to be a conflict of interest?
I'm sorry, could you explain that? Ministerial Code investigation?
So there is an investigation under the Ministerial Code done by James Hamilton. I understand that James Hind has been assigned to that. Is that a conflict of interest?
No.
Okay, thank you, Convener.
I have two short supplementaries, and then we'll go on to Angela Constance as the final contributor. So Margaret Mitchell, followed by Alistair Allen.
Thank you, Convener. If I could very briefly return to this informal, confidential sounding board role, which I think you said was in place, the individual, just for the unique circumstances of #2. It provided a private, formal and supportive space where that person could signpost and guide you to support or move to a formal action if required. Can you explain why that wasn't continued? I mean, from your evidence, I'm understanding there is no longer a person in that place. If an employee came forward who had experienced a past incident of sexual harassment and wanted to raise it in this way, we know these circumstances, it can be a little while before people come forward. So surely good practice would dictate that that was continued and wasn't just put in place for these particular circumstances.
I mean, I think that's a very good point. It was very deliberate to appoint somebody who would be good in that role and would also be able to have the time and have the trust from other people in the organisation to undertake that role effectively. So, but it's also quite an onerous role. It certainly was at that point, as you might imagine, during a time when there was so much going on and many people approached the individual. So it's not a formal part of the procedure. My reflection is, and Laura Dunlop will be advising us about one particular aspect of the procedure, but she may wish to make other comments, is whether or not that is something that we would want to make a more permanent process. So somebody that would always be sitting outside the traditional confines of HR and would have that additional care and confidence role. It wasn't that we deliberately stopped the role. It was more that we found that the use of the role was then, fewer people were coming forward at that time. But I think there is learning for us in all of this procedure. And I hope I'm not giving anybody the impression that there isn't. This one aspect of how valuable that role was, and it wasn't in the formal procedure, proved to me the importance of it. And I think we may well wish to think about how we preserve some element in the future.
Alistair Allen.
Thank you, Convener. You mentioned a little while back about how, I don't want to put words in your mouth, you said something like ministers were not involved in the development of the policy. While I understand that ministers would have been involved, or cabinet would have been involved in the sign-off, am I taking it from what you said that they weren't involved in what you call the iterative process around the formation of the policy, or can you elaborate on what was meant by that?
No, they weren't involved in the iterative process. It's quite normal, as you all know, having been a minister, that we look through versions and hold them up to the light and consult with people. So whilst that was happening, and it was quite an intense process for reasons which I explained to Ms Constance earlier on, ministers would not be particularly involved in that.
Thank you.
Finally, Angela Constance.
Permanent Secretary, going back to the point about the evidence from the FDA, who called for a fully independent process for the investigation of ministerial harassment complaints akin to what exists in the House of Commons. Instead, we have an internal investigation process. Why is that?
So I think I mentioned earlier on to Ms Bailey that the Westminster process, the independence of the Westminster process is pretty recent. It's well after our procedure was developed. In fact, I think originally it wasn't. It didn't have any independent element to it.
Process?
No, I'm talking about
asking
timing.
Why we opted not, why the government opted not to have an independent, externally independent investigation process.
Yes, I understand that, and I'm trying to explain it. The employment it is an employment policy. It's unusual in employment policies to have any independent element until after the procedure has been exhausted. So ACAS would become involved as an independent element, and so would the Employment Tribunal. And that was the lens through which this procedure was developed. In other words, it was an employment, predominantly looking at as an employment policy. Now, since then, clearly, Westminster has decided to inject an independence element. At the time when we were developing ours, interestingly, it wasn't raised by the unions. It wasn't raised as to whether we should have an independent element. We will be looking and learning, going back to the Laura Dunlop process and deciding whether there should be at some point an independent element injected into the procedure. I am not against that, but I'm just pointing out that Westminster have followed on from us in having a written procedure and have subsequently been pressured by the FDA successfully to include an independent element there. And it may well be that we will find that's the best route in future. We're not at that stage yet.
I understand issues of employment policy and employment law are complex and can require lengthy consideration. But when you signed this policy off, a policy that was developed between the 31st of October and signed off on the 20th of December, when you signed that policy off, were you absolutely confident about the robustness of this policy?
I was. It had been informed by legal and HR expertise throughout.
Okay, thank you.
Thank you very much. I've just got one final question, please, Permanent Secretary. You've referred quite a few times to the investigation by Laura Dunlop QC. Could you tell me the timeline for that and when that's likely to conclude and report?
I don't have a final timeline. I think it was expected to last around 3 months, but I can write to you with the anticipated timeline based on what has been progressed so far.
Okay, thank you very much. And can I also thank you for coming along today and answering our questions. There's a few things that we'll pick up, as I'm sure your people will too, about the potential for written evidence to come here. I'd also remind everyone that we have 2 officials from the Scottish Government coming next week to give evidence. And can I ask the Permanent Secretary that she and her team reflect on some of what was said today, particularly the letter from the Deputy First Minister and legal privilege and verbal evidence, which one of my colleagues raised, and perhaps have a discussion about how evidence can be given next week. Can I say I've also got some concerns, as has the committee, about the redactions in some of the information that has been sent in. So I would ask that there be further consideration given to some of that for discussions with parliamentary officers and government officers. Again, we may invite you back, Permanent Secretary, after we've listened to your colleagues and indeed the trade unions, perhaps for more of this discussion, although I'm sure we will see you further on in the inquiry about the other elements. Thank you again for coming.
Thank you.
And this meeting is now closed and we move into private session.